Welcome, everyone, to the Forensic Investigator Podcast, hosted by Dr. Jim. As previously stated, I bring to the table decades of training, education, and experience to include authoring 3 books and lecturing around the country and in Europe on homicide and cold case investigations. I remain active in the field, offering certified training to law enforcement agencies and case consultations for detectives, attorneys, and families. In the last episode, I discussed the first Forensic Investigator Foundation, where I defined forensic science, the forensic investigator, and listed many of the forensic disciplines that exist in our society today. In this second episode, I want to provide another foundation about the forensic investigator, which involves the legal considerations and concerns that the investigators face throughout the investigative process. As a disclaimer, however, I am not an attorney, nor have I studied law. What I'm about to give you is a thumbnail sketch of some of the legal requirements that exist and is not all-inclusive. The information is based on many years of experience dealing with these legal matters on a regular basis, which is supplemented by research of viable sources with some assistance from verified AI data. In the first topic for today, I will provide you with an overview of criminal laws and jurisdictional issues that we face in the U.S. Criminal laws in the United States are shaped by jurisdiction, authority, and scope. Federal laws address national interest and crimes that cross state boundaries, while state laws govern offenses within individual states, and local ordinances regulate the minor violations at the municipal level. When federal and state laws conflict, federal law prevails, and federal cases often result in stricter penalties. So what are the key differences between criminal laws? Well, let's start with jurisdiction and scope. At the federal level, these are crimes against the U.S. government, offenses crossing state lines, or crimes committed on federal property, such as mail fraud or kidnapping. The state covers most criminal cases, including murder, assault, DUI, and theft, when these occur, though, within a single state. And local municipal laws usually addresses minor, localized offenses like noise complaints, jaywalking, or city code violations. But when it comes to law enforcement and prosecution, we find at the federal level, investigations are handled by agencies like the FBI, DEA, or ATF, and prosecutions occur in federal court by U.S. attorneys. Whereas at the state and local level, local police or state troopers investigate, and district attorneys or local prosecutors handle cases in state or municipal courts. Then, when it comes to sentencing and penalties, the federal typically involves mandatory minimum sentences and follows strict federal sentencing guidelines, while state sentencing is more flexible and varies according to the state law, often allowing for indeterminate sentences. With that said, 2 things should be kept in mind. There is a supremacy clause that basically states that federal law overrides state law in cases of conflict. And then there is dual sovereignty, where both federal and state governments can prosecute the same act without violating the Fifth Amendment's double jeopardy clause. Common examples would be federal drug trafficking across state lines, bank robbery, immigration crimes, tax evasion, whereas with the state we see robbery, murder, burglary, state or local drug possession, local violations of local ordinances such as curfew or noise restrictions. From the criminal laws and jurisdictions, I will proceed to the evidentiary procedures relative acceptance and exclusions of evidence. Here we find that evidence must be relevant. It must directly relate to the case and have probative value. It must be reliable, where the sources are credible and can be authenticated, such as with documents and expert testimony. Then the evidence has to be admissible, which is governed by federal rules of evidence and state rules. Next, we have exclusions, where the evidence can be excluded if it is unfairly prejudicial, it's confusing, from hearsay, or not obtained constitutionally. And finally, the evidence must be authenticated, where documents and objects must be shown to be unchanged since the event. So the key is that all evidence must be relevant, reliable, admissible, possibly have exclusions, and lastly, the evidence must be authenticated. Now, continuing with the topic of evidence admissibility and including expert testimony, let's examine the criteria established by two Supreme Court decisions. The first is the Frye test, F-R-Y-E, and then there is the Daubert standards, and that's D-A-U-B-E-R-T. The Frye test basically states that admissibility depends on general acceptance in the relative scientific community and restricts new science until it is widely accepted by that scientific community. However, with the Daubert standard, the judge functions as the gatekeeper, evaluating the reliability, the validity, and relevance using factors like testability, whether it was peer-reviewed or not, what are the error rates, and standards. This applies to all expert testimony, not just novel science. However, keep in mind that while the federal court system and many state courts have adopted the Daubert standard, several states still adhere to the Frye standard, or maybe a hybrid version. Daubert generally allows for more flexibility, and in some cases, easier admission of newer, well-tested technologies that may not yet be widely accepted. To sum this up, the focus of Frye is general acceptance, while Daubert is reliability, validity, and relevance. The gatekeeper for Frye is the scientific community, but with Daubert, the judge decides. Criteria for acceptance is widespread with Frye, while the Daubert decision requires testing, peer review, an accounting of error rates in that testing, and standards in acceptance. Now, another consideration is with expert testimony under the guidelines of the Federal Rule of Evidence 702. Under this rule, persons are qualified as experts based on knowledge, skill, experience, training, and education, and are permitted to offer expert opinion testimony if the following conditions have been met. Number one, the expert's scientific, technical, or other specialized knowledge will help the trier of fact so as to understand the evidence or to determine a fact in issue. The testimony is based on scientific facts or data. The testimony is the product of reliable principles and methods. The expert has reliably applied the principles and methods to the facts of the case. The federal courts are all governed by Daubert. With this rule in mind, each state also has a rule of evidence that defines the criteria under which an expert can testify. In most states, this rule is codified as Rule of Evidence 702. Some states may apply Daubert, other states apply Frye, yet other states may apply a modified version of Daubert or Frye. Still, other states have their own standards of admissibility. Finally, some states apply Daubert in some circumstances and then go to Frye in others. Now, if you're not already confused by that, I'd be surprised. So it behooves you to have a full understanding of all the rules that apply to you in your jurisdiction, because these rules and laws are forever evolving and may be different. Now let's talk about Miranda and the Fifth Amendment. Legal guidelines regarding Miranda rights established by the landmark Supreme Court case Miranda v. Arizona, 1966, require law enforcement to inform suspects of their constitutional protections before conducting what is called a custodial interrogation. Now, there are 4 required warnings, and while exact wording can vary by jurisdiction, officers must convey these 4 essential points. The right to remain silent, that anything said can and will be used against them in a court of law. The right to have an attorney present during questioning. The right to a court-appointed attorney if they cannot afford one. But let's go back to the initial definition. Miranda requires law enforcement to inform suspects of their constitutional protections before conducting a custodial interrogation. Those constitutional protections are obviously the 4 warnings, but please note, it also states before conducting a custodial interrogation. Therefore, there are core requirements for Miranda guidelines to apply where 2 conditions must be met simultaneously. First of all, custody. The suspect must be under formal arrest or in a situation where a reasonable person would not feel free to leave. Interrogation. Police must be asking questions or engaging in conduct reasonably likely to elicit an incriminating response. What about the nuances that may apply? Well, invocation. To stop an interrogation, a suspect must clearly and unambiguously state they are invoking their rights. For example, I want a lawyer. Remaining silent is not enough to legally invoke the right. Waiver. Suspects can waiver these rights, but the prosecution must prove the waiver was made voluntarily, knowingly, and intelligently. Consequences of violation. If rights are not read during a custodial interrogation, any resulting statements are typically inadmissible as evidence of guilt. However, they may still be used to impeach the defendant's testimony if they take the stand. Civil immunity basically states that individuals cannot sue police officers for damages solely for failing to provide Miranda warnings. And what are the common exceptions? Well, there is one. There's one here called public safety. Officers may ask questions without warning if there is an immediate threat to public safety. For example, asking for the location of a discarded weapon. Routine booking. Questions regarding basic biographical info, such as name, address, date of birth, etc., do not require a Miranda warning. undercover agents or police officers. Miranda does not apply if a suspect voluntarily speaks to someone they do not know is a government agent. And outside of a custodial situation, such as being at your doorstep and asking questions, law enforcement is not required to advise you of your rights until or unless they have a strong enough reason to believe you committed a crime, believing that the most probable action would be to arrest you, and then you are being restrained and in a custodial situation. Next, let's take a look at the search and seizure rules based on court decisions in the Fourth Amendment. An overview of the Fourth Amendment states it safeguards individuals from unreasonable searches and seizures by the government. Generally, law enforcement must obtain a warrant supported by probable cause to search areas where there is a reasonable expectation of privacy, such as a home. Evidence obtained in violation of this protection is typically inadmissible in court. And there are some key principles. Privacy protection is the first. The amendment prohibits arbitrary government intrusion into persons' residences and persons, the documents, and belongings. Expectation of privacy. There are protections that apply where an individual has a legitimate expectation of privacy, both subjectively and objectively. What about the warrant requirements? Searches usually require a judicial warrant specifying the location and items involved. But there are exceptions to the warrant requirement. Warrantless searches are permissible under certain circumstances, including consent, where voluntary permission from an authorized individual is provided. Search incident to an arrest, searches which are searches of a person and immediate surroundings following a lawful arrest. Then there's exigent circumstances, emergencies such as pursuit of a suspect, imminent evidence destruction, or prevention of harm to himself or others. Then there is plain view, evidence in plain sight where officers are lawfully present. Then there's the automobile exception, searches of vehicles with probable cause for contraband. Note, probable cause must exist. Stop and frisk, brief detention and pat-down based on a reasonable suspicion of criminal activity and potential danger. Search warrants' key requirements are probable cause, that the facts establishing that a crime occurred and that evidence is likely located at the specified place. Particularity, a clear and specific description of the location to be searched and the items to be seized. Judicial authorization must be issued by a judge or magistrate and not law enforcement. Execution limits. Compliance with time and manner restrictions as set forth in the warrant. Common applications. Search warrants are commonly used in drug investigations, digital evidence collection, financial crime cases, and investigations involving weapons or forensic evidence. Exceptions, although warrants are generally required, exceptions include consent searches, items in plain view, and exigent circumstances. Now, let's talk about seizure of persons and property. A seizure occurs when the government exercises control over a person or property. A person is considered seized if, due to official conduct, a reasonable individual would not feel free to leave. And there are consequences of violations. For example, evidence obtained through unreasonable searches or seizures is generally excluded from criminal proceedings under the exclusionary rule. And finishing up with this, I want to address one more area relating to the evidence. All evidence must have a reliable and unbroken chain of custody from one person to another, to a lab, and to the court. Why? Because this ensures the integrity of the evidence from the point of collection to the courtroom. Breaks in that chain lead to exclusions, maybe reduced charges, or even an acquittal. You have to avoid and be able to show the court that the evidence in question has not been tampered with, that it has not been contaminated, does not contain documentation, errors, and has been securely stored from point in time of collection to the point in time it arrives in court for legal consideration. Now let's go at closing of that. From this podcast, you should have a basic understanding of the legal requirements and of the foundation for the forensic investigator as he faces throughout the investigative process. From having a knowledge, at least a thumbnail sketch of knowledge of the laws and the rules that the courts follow for the acceptance of evidence and expert testimony. You have also heard the basics of the Fourth and Fifth Amendment as they relate to searches and seizures, and the Miranda warnings as they apply to the procedures utilized by the forensic investigator. In our next episode, I will have a guest speaker who is a retired detective from the Wisconsin Attorney General's office. He will address the roles and responses of the lead detective upon their first arrival to a homicide crime scene. I want to thank you for being with me, and please join us for the next episode. Remember, if you have any questions about this podcast or the forensic services I provide, please email me at jma.forensicinvestigator@gmail.com or visit my website at www.jma4ensics.com. I hope you have a great day and week. Thank you for listening. Bye.